This is Bloomberg Law with June Grasso from Bloomberg Radio.
President Joe Biden is expected to announce an executive action that would give undocumented immigrants who are married to U.S. citizens a path to citizenship. This, as Biden's last executive action, putting in place a restrictive new asylum ban, is being challenged in the courts. Joining me is immigration law expert Leon Fresco, a partner at Holland Knight. Leon, tell us what you know about this new executive order on immigration.
So tomorrow, there's going to be an announcement by the Biden administration, which will take what is estimated to be about 1 million people who are here without lawful status. What they did was they crossed the border illegally. But after they crossed the border illegally, they married a U.S. citizen. And so there's this very often misunderstood part of the law where people think, oh, if you just marry a U.S. citizen, you're fine. You can get a green card. But that's actually not true. That's only true for people who overstayed a visa that they entered in lawfully. But if you actually walk across the border illegally, you actually cannot get a green card. You have to leave the United States and apply for a waiver and hope you get it. And so a lot of people won't take that risk. Well, the Biden administration is announcing a process called parole in place, which is saying you no longer have to leave the country. You can stay here in America, and we will parole you in the country, meaning we will pretend like you entered in legally so that you now have the ability to apply for a green card based on this marriage. And so that will literally give a path to citizenship to about 1 million people who did not have it previously.
Are they giving them any more rights than they had before, or are they just saying you can do it here, you don't have to go back to your home country?
So the right that they're giving them is the right to do it here, because the point is that ability is not exactly clear in the law whether it exists or not, which is, can you parole somebody? Because a parole, here's what a parole is. People think of parole during the normal definition of the word, which is you're in prison, you get let out early. But in immigration, that's not what a parole is. In immigration, what a parole is a permission slip to be let in the United States, even though you don't have any reason to be here. But what happens is that permission slip can be revoked at any time. But usually that permission slip is given to you at the border, at a port of entry, at the border when you apply, and it's not given to you from inside the country. Well, a few years ago, there was this thing invented called parole in place. The idea was you didn't have to be given this permission slip at the border. You didn't have to leave and come back. You could literally be given it while you were inside the United States because there was nothing technically in the law that prohibited it, so why couldn't it be done? And it was done in the context of people who crossed the border illegally and not just married U.S. citizens, but literally married U.S. citizens who were in the military. There was a program that was done during the Iraq War that said, look, if you were going to go to the Iraq War, you should not have to worry that your undocumented spouse would be deported if you died or if something bad happened. So we're going to parole in place your undocumented spouse so that they can have a path to a green card. And that actually still is the law, which is nobody's actually challenged that if you were the undocumented spouse of a U.S. military person, that person could get a parole in place. So now what the Biden administration would be doing is trying to expand this experiment to everybody else, not just spouses of U.S. military people, but literally any U.S. citizen. And so the question will be, obviously, will there be lawsuits filed and will those lawsuits be successful?
If you came here illegally and you married a U.S. citizen, does that normally get you citizenship when you go through the process?
So only if you entered legally and overstayed your visa could a marriage fix your situation. If you entered illegally, if you crossed the border without anybody detecting you, and then you tried to fix your situation by marrying a U.S. citizen, that actually requires you to apply for a waiver at an embassy abroad and hope that that waiver is granted to you in order to re-enter. And that is why many, many people do not do that, because they are terrified that they will not be let in because that's a discretionary waiver. And if you don't get it, you have no legal recourse. You cannot sue. You cannot do anything. And so most people who cross the border and marry a U.S. citizen are not willing to take that process. And so this would obviate that need and would allow them to apply for a green card without leaving the United States. This would allow them to do it from within the United States.
Being married to a U.S. citizen, does that, weigh in your favor when they're considering whether or not to give you citizenship?
So there's a category of getting a green card called spouse of a U.S. citizen. So in any case where a U.S. citizen marries someone who is not a national of the United States, as long as they follow all the rules, that person can obtain lawful permanent residence. So that exists. So anybody who's a U.S. citizen today can go to Sweden or Namibia or Australia or wherever, China, and marry a foreign national. And so long as that foreign national isn't a terrorist or a drug dealer or something else, they can go through a process to get that foreign national lawful permanent residency. What this is changing is just that there's a barrier that exists, that marriage isn't enough to give the person lawful permanent residency in a case where that person snuck in across the border illegally. So in those cases at the moment, it doesn't work. You can't get a green card based on marrying a U.S. citizen. But what Biden would do is he would change this so that you could get a green card even if you crossed illegally and married a U.S. citizen.
So, is it likely that most of those 1 million people will be getting green cards?
Well, this is going to be the challenge. There's going to be basically 3 challenges to this. First will there be a court decision that enjoins this? And, I'm sure there will be people that challenge it, states and perhaps other interested groups who challenge this and say that it's illegal. Secondly, there is the election coming up. And so let's say there's really 1 million people who are applying for this process. If Trump wins, there's no way that the 1 million people who will have joined the line in order to get their case processed, probably almost none of them will have had their case processed by the time Trump comes into office. So he can just cancel all of those applications and say, thank you very much for paying your fee. I don't care. I'm canceling this, end of story. And that's going to be the end of that. And so that's problem number 2. And then problem number 3 would be, well, those people, do they have other problems within their cases that would prevent them from getting green cards? Maybe they broke other laws while they were here because they were here without status. Maybe they used fake IDs or other things like that. So on a case-by-case, it's not going to guarantee that everybody could get those green cards. It would say a lot of them could, but they're going to have to wait long amounts of processing time, and they're going to have to hope that Biden gets reelected.
I'm wondering, what are the reasons that you could give in that situation for wanting a green card? Is it that you fled persecution, or is it something different?
No. The only reason you have to give is I'm married to a U.S. citizen. That's it. That's enough. But the problem is you can't give that reason right now if you've crossed the border illegally.
If Biden stays in office, then let's say, 90% of the 1 million people will get green cards
eventually. Correct. That is correct. Even when they ever get around to doing those cases. But yes, correct.
Why is Biden issuing this order now when he's been trying to show he's tough on illegal immigration? Just on June 4th, he effectively halted asylum claims at the southern border.
The idea is this would be the equivalent of taking the child's aspirin and putting it in some sort of fruit juice or something, and that this would allow it to be able to be swallowed, what was being done in the border in regard to asylum, with also sort of saying, but look, at the same time, I'm doing everything I can to help people who are in the immigrant rights community and in the immigration world to try to show that I'm compassionate for people, et cetera, and maybe try to take some of the votes for people who are the U.S. citizens in these relationships and try to, get votes from those people and their families and anybody else. I don't know. But I think that's sort of the understanding of why this is being done now.
And what would a cause for states to challenge be? States or counties or cities?
Sure. So I think what you're going to see is they're going to argue that the parole program is supposed to be an individual case-by-case determination in a humanitarian circumstance. And anytime you make these programmatic parole decisions that are not case-by-case, but that are writ large applying to categories of people, you can't do that. And so that would be why it would be illegal. And also that Congress specifically wrote these barriers to prevent people who cross illegally from accessing green cards, such that this wasn't a reason to give a parole. A parole would be for a reason that's idiosyncratic and unique to a specific person's case because of something else that popped up. But the statute is literally working the way it's intended, which is to punish people who cross the border illegally from being able to benefit from that, and that this would actually then subvert the way that the statutory scheme is supposed to work. Now, the question is, will the states have standing to make those claims? And so they'll have to show that they're being damaged in some way through this program, and we'll have to see what arguments they can make for that, for how the states themselves are being damaged by the giving of green cards in these situations.
Okay, stay with me, Leon. Coming up next on the Bloomberg Law Show, we'll discuss those lawsuits against Biden's executive action, effectively ending asylum at the southern border. Also, the Supreme Court's decision on immigration. I'm June Grasso, and you're listening to Bloomberg. President Joe Biden is expected to announce another executive action on immigration that would give undocumented immigrants who are married to U.S. citizens a path to citizenship. This as Biden's last executive action of June 4th, which effectively halted asylum claims at the southern border, is being challenged in court by a coalition of immigrant advocacy groups. The lawsuit filed last week is the first test of the legality of Biden's sweeping crackdown on the border. I've been talking to immigration law expert Leon Fresco of Holland Knight. It took a while for the ACLU to file a lawsuit against the executive order. We thought it was going to happen right away.
When they filed it on June 12th in the D.C. District Court, I think what happened was they were trying to figure out, first of all, what venue to file it in, and secondly, it wasn't just a Biden-era announcement. They needed to actually sue once the rule was published, and so that delayed the lawsuit a little bit because they needed to actually publish the rule itself so that they could sue on the published rule, not just the press release. And so that rule was published on June 7th, and so they took the published rule on June 7th and they filed the lawsuit on June 12th. So, yeah, it wasn't the normal immediate, speedy lawsuit that they do the same day, but they did file it 5 days after they could file it.
So they're saying that it's the same as what happened with former President Trump and that this is against the asylum laws?
Correct. What they're basically saying is that the asylum rule that Biden has passed, or that he promulgated, the ban, basically violates the Immigration and Nationality Act, because what they're saying is that the statute is very clear in saying that you can apply for asylum even if you cross in between the ports of entry illegally, and that any ban that you are putting in for that purpose isn't permitted because the ban, well, first of all, is a ban on entry. It isn't a ban on people who already entered, so it can't be used as a ban on asylum. But also that the ban law, which was put in the 50s, was before the asylum law. So the asylum law, which was put in the 80s, that had this, clearly contemplated that you could cross in between the ports of entry such that you couldn't ban this. That would be the whole point of it. And so those arguments were previously successful in the Ninth Circuit, and so the question is, will they be successful here in the D.C. Circuit?
I'm surprised that they didn't file in the Ninth Circuit, where they were successful before and where there's a precedent.
I think the reason they filed it in the D.C. Circuit is because they believe that this is actually a challenge to the expedited removal statute now, because of the way the Biden administration geared the statute. They wrote it in a way that basically forced the challenge to have to be in the D.C. district, because what happens is that if you're challenging a change to the expedited removal regime, as opposed to just the 212F ban, there's a statute that says that has to be done in the D.C. court. And I think this is another reason this lawsuit was delayed, is because they realized that the way the Biden administration crafted it, they took it out of the jurisdiction of the Ninth Circuit and put it in the jurisdiction of the D.C. District Court and then ultimately the D.C. Circuit.
A lot of immigration law disputes happening, Leon. And last week, the Supreme Court sided with the federal government in a deportation notice dispute. Tell us about that.
So, in that case, that's a case last week called Campos Chavez versus Garland. And so this is literally the third Supreme Court case in the last 3 years that has to do with this issue of what the notice you give to immigrants is when you place them in deportation proceedings and whether it's proper or not, and how do you fix that. And this starts with the process of when you enter America illegally, you immediately get a piece of paper from the government, if the government finds you, of course, called a notice to appear. And that notice is supposed to have the time and the date and the location of your proceeding. So what the first two cases said is if you don't have that, the court doesn't have jurisdiction over your case, and the court doesn't start building toward this stopping of how long your case has been pending, because your case wouldn't have been pending because you were not served properly with a notice that had the time and the date. So in this third instance, we weren't debating this, but instead the case was about, well, what happens if you get one of these notices that at first doesn't have the time and the date, but then you get a notice, and that's not disputed, you actually do get a notice that says, hey, the time and the date of your proceeding is, let's say, March 15th, 2 p.m., Chicago Immigration Court, 111 Jones Street. And then what happens if you don't show up to that hearing? Can you say, well, I wasn't given the right notice in the first instance, so immigration can never fix this ever again? They have to serve me with the right notice again, but personally. They have to come give me this personal, correct piece of paper, or can they just give you a hearing notice? And so what, oddly enough, this decision says, and it's a 5-4 decision, and Gorsuch actually goes over to the side of the liberal justices, but it's not enough because Alito, Roberts, Thomas, Kavanaugh, and Barrett formed the 5. They say that even though you could go to this hearing if you showed up and get it dismissed by saying that the notice was wrong, you can't just not show up. If you don't show up, you can be ordered removed, and there's no way to fix this. So the fact that you got a bad notice up front doesn't give you a right not to show up to the hearing at all if you got a notice telling you you needed to show up to the hearing. That the government could still deport you for not showing up to the hearing, because if you want to make the argument that you got a bad notice, you still have to show up and do it. You can't just not show up. And I think this was probably more a process-oriented decision than a legal decision, because I don't see how you can square this precedent with the first two decisions. But I think they just didn't want people to take matters in their own hands and just say, well, I don't have to show up, and I never have to show up, and I never have to be accountable to the immigration system. So they said, no, you have to be accountable. You have to show up, and if you want to make arguments then about your notice being defective, go ahead and do it then, but you can't just refuse to show up.
Samuel Alito, who wrote the majority opinion, said that it blocked immigrants from seeking to challenge removal orders, quote, in perpetuity based on arguments they could have raised in a hearing that they chose to skip. Is it that they chose to skip the hearing, or they didn't know about the hearing? They didn't get the notice?
So this is what's complicated.
It's always complicated with immigration laws.
So here's the point. They did get a notice, and in order to trigger the in absentia removal provision of the statute, you have to show that you got a notice. But what they're saying is that that notice that you have to get to trigger the in absentia is not the same notice you have to get to trigger the entire removal proceeding. So this is what they said. So they said as long as you get any notice that clearly shows that you were told you have a hearing on March 5th, 2024, at 11 a.m. at the U.S. Immigration Court in Chicago, 111 Jones Street. If you got that notice, you've got to show up. It doesn't matter that you didn't get the correct notice to appear that's required by statute that has all the information. That's the notice you need for the court to have jurisdiction over your case. So if you didn't get that, you can show up at your hearing and say, look, you've got to dismiss my removal proceedings until I get the right notice. You have that argument, and you will win that argument. But what Alito is saying is you can't just not show up, because the statute that allows the U.S. to deport you when you don't show up doesn't require this notice. It just requires any notice. And so if you got a notice that gave you a time and a date, too bad, you lose.
One of the illegal immigrants in the case before the Supreme Court said he has 2 children who were born in the United States, and they would face exceptional hardship if he were deported. I'm just wondering, as far as immigrants who have children born here, does that help their case against deportation?
So it depends again. So again, more of the it depends. There is a provision that allows you, if you've been here 10 years and you have U.S. citizen children, that you can say what's called cancellation of removal, meaning you can ask the government to take sympathy for you and give you an administrative relief called cancellation of removal that allows you to stay if you can show, and here's the key, exceptional and unusual hardship to one of those U.S. citizen children. So, for instance, maybe one of those children has some disease that can only be treated in the U.S., something of that nature. And you're their breadwinner, and you can't, if you go to that home country, A, you're not going to be able to make money to pay for the treatment, and B, that treatment's not available in that country. And so that's that kind of argument you can make, but you can't make it if you don't show up to the hearing. So for somebody who wanted to make that argument, if they didn't show up to the hearing, what Alito is saying is too bad. You've lost now. There's no way you're going to be able to revive your case to make this argument when you didn't show up to the hearing.
Leon, what do you think of the reasoning of the majority in this decision?
Well, the irony is that this is kind of a bungled decision in the sense that what they're saying is, even if the court in the end doesn't have jurisdiction to hear your case and you would have been able to make that argument, you still can't skip the court proceedings. I don't know of an analogous case ever like this where the court is saying, and this is why Justice Gorsuch didn't go for it, that a court can deport you in a hearing that it theoretically didn't have jurisdiction to even have the ability to have the hearing. But this is what they've decided, and I think this is a bad fact, bad law, good fact, good law type situation where I think 5 justices of the Supreme Court, and especially Justice Roberts, who's a very swing vote and usually tries to do something practical in a lot of these cases, just thought, I don't think it's practical to allow a regime that just allows people to skip whenever they want immigration court. And I think that just couldn't settle enough for Justice Roberts, and I think that's why they put in this decision.
Always a pleasure to have you on, Leon. Thanks so much. That's Leon Fresco, a partner at Holland Knight. Coming up next on the Bloomberg Law Show, what the Supreme Court's ruling on bump stocks means for gun regulation. A sharply divided Supreme Court threw out the federal ban on bump stocks, the rapid-fire gun accessory used in the deadliest mass shooting in modern U.S. history, where a gunman fired more than 1,000 rounds into a Las Vegas crowd in 11 minutes, killing 60 people in 2017. In a 6-3 decision down ideological lines, the court's conservatives said regulators exceeded their power by outlawing the rapid-fire devices. In light of that decision, Senate Majority Leader Chuck Schumer said the Senate will vote this week on restoring a ban on bump stocks.
By undoing this most common-sense safety ban on deadly bump stocks, this MAGA Supreme Court has shown the American people how dangerously to the far right they have gone.
Joining me is Joseph Blocher, a professor at Duke Law School. Joseph, this case isn't about the Second Amendment. Explain what the issue is here.
This is not a case about whether the government can prohibit bump stocks. That was not the question before the court. It's not a Second Amendment argument. It's not a constitutional argument. The question is whether the ATF can, under the existing statute, treat bump stocks like machine guns. Current federal law has a lot of restrictions that apply to machine guns, and it defines machine guns as a weapon that can automatically fire more than one shot without manual reloading by, and this is the key phrase, a single function of the trigger. And what bump stocks do is essentially take a semi-automatic weapon, that is one that fires a single bullet with each separate pull of the trigger, and makes it function like a machine gun, that is an automatic weapon, one where you hold down the trigger and bullets continue to go. And the way a bump stock does that is it harnesses the recoil of the weapon essentially to bump it, that is the weapon or the trigger, against the finger of the shooter so quickly that, in effect, a rifle outfitted with a bump stock can shoot 400 or 800 rounds a minute, which, looks like a machine gun and sounds like a machine gun. If you've seen or heard the footage from the Las Vegas shooting, for example, that involved a bump stock, it sounds like what most people imagine a machine gun to be like. So this case is really about, can bump stocks be treated like machine guns under the existing statute? That's really, really important.
And how did Justice Clarence Thomas come to his decision that, quote, a bump stock does not convert a semi-automatic rifle into a machine gun any more than a shooter with a lightning-fast trigger finger does?
It's a really interesting opinion in that Justice Thomas is using images from an amicus brief to illustrate in some detail how a bump stock works. And he's really focused on the mode of action by which the trigger activates the firing mechanism. And the basic takeaway from his opinion, I think, is that the trigger has to be reset each time. And the bump stock itself is really just the technological equivalent of a person with a lightning-fast trigger finger. Like, the trigger itself has to be depressed repeatedly. And so on his reading, that means that that's more than a single function of the trigger, and therefore this can't be a machine gun. I think the difference between his opinion and Justice Sotomayor's dissent, capture it in a sentence, is Justice Thomas is focused on things from the perspective of the gun, and Justice Sotomayor is focused on the action of the shooter, the perspective of the shooter. And she points out a single initial pull of the trigger initiates the firing sequence, and then as long as you hold your finger in place and keep enough pressure on the gun, it continues to fire without you having to do anything else. And so for her, that's a single function. In a nutshell, I think that's the difference between how they're looking at this case.
Is what Thomas says technically correct?
Yeah, I don't think that there's anything in the majority opinion that I see that's technically wrong. It's just a question of how you frame the inquiry here, right? Like, what is the question one needs to ask to figure out whether a gun automatically fires more than one shot by a single function of the trigger? But, the diagrams that he shows, as far as I can tell, are entirely accurate. It's just a question of, is that the right way to understand what the question is? And again, Justice Sotomayor's point is, it is equally accurate to say that with a single pull of the trigger, as if you focus on the finger itself, the weapon will fire like a machine gun. And that's why she says in the opinion, I think I got this quote right, when I see a bird that walks like a duck, swims like a duck, and quacks like a duck, I call that bird a duck. And, right here she says these guns, they fire like machine guns, and therefore the ATF can choose to call them that. And I should say the ATF rule here was adopted in 2018 during the Trump administration in the aftermath of the Las Vegas shooting. There was pretty broad bipartisan support for it at the time. So, what happens next is kind of an open question.
This is a 6-3 decision down ideological lines. Does it really come down to the 6 conservatives are not in favor of restrictions on guns and the 3 liberals are in favor of restrictions on guns? And the outcome is determined by that.
That does accurately describe the way that the lineup have shaken out. But I think in this case, anyway, there's almost a methodological divide between the justices, which is even more fundamental maybe than their views on guns. Of the justices in the majority, based on oral argument and even based on a pretty remarkable concurrence that Justice Alito wrote, I think they have a lot of sympathy for the prohibition on bump stocks. Justice Barrett seemed to be signaling that at oral argument. Justice Alito has this concurrence where he agrees with Justice Thomas that the ATF can't prohibit this, but he also goes on to say there can be little doubt that the Congress that enacted this law would have not seen any material difference between a machine gun and a semi-automatic rifle equipped with a bump stock. So you read that and you think, oh, well, he's going to vote for the government here. But then he goes on to say, but the statutory text is clear and we must follow it. So I think the methodological division here, again, to oversimplify a little bit, is between the justices in the majority who see this as a case about clear text, that a single function of a trigger cannot include the bump stock because the trigger has to be depressed repeatedly. And the justices in the dissent disagree about that text, but also, I think, believe that the purpose of the statute is clear and should play a role here, which is the Congress that enacted this would have allowed the prohibition on bump stocks, and so would have gone the other way. So in addition to the gun thing, I think there's a methodological dispute here as well.
Is it also about the power of the ATF, the federal agency here, to enact and interpret regulations, which is really almost a theme this term at the court? We're going to see a lot of cases about agency authority.
Yeah, one of the interesting dogs that doesn't bark in this case is the status of what's called Chevron deference, right? So under the principle of Chevron, which is a case which is sort of foundational to the way the administrative state works, courts will defer to agencies' reasonable interpretations of ambiguous statute. So if the statutory text isn't clear, and let's say the EPA or the ATF is charged with enforcing that statute, if they adopt a reasonable interpretation of it, then courts will say, okay, we'll let that stand. And there's a separate case before the court right now, a case called Loper-Bright, which really presents straightforwardly the question, should Chevron be overruled? And for administrative law scholars, I think that is the single biggest question for administrative law, and I don't even know how long. I mean, that's the basis for how so much administrative law and therefore agencies works. Now, this case arguably has some ambiguous text, that this single function of the trigger text. And so you might say, well, look, the justices disagree about what it means, and therefore it's ambiguous, and the ATF has adopted what might be a reasonable interpretation, that is, that bump stocks, can constitute machine guns. But the government below disclaimed reliance on Chevron, and so it's not even cited in any of the opinions here, which is a little interesting because it is an agency case. I don't know what that signals about what's happening in Loper-Bright, which we haven't received yet, but we'll see.
Does this decision in any way indicate the outcome of the Rahimi case, which is about a federal gun ban for people subject to domestic violence restraining orders? Although in that case, it seemed like in the oral arguments that many of the justices were on board with the ban.
Yeah, it's, I think, very different. Just there's no Second Amendment claim in this case. The methodological questions are very different. At the oral argument in Rahimi, at least, it sounded like most of the justices, at least, were on board with the government's argument. Remains to be seen how that'll shake out. There'll be lots and lots of different ways that could go. And, that opinion has been out since the first week of November. It's a long time. So, maybe wondering exactly how that's kind of splintering.
Yeah.
At this point, it's starting to feel to me like it's going to be more than two opinions, like more than just a majority and a dissent. But, I guess hopefully we'll be seeing soon.
Well, less than 2 weeks left in the term, so we'll see it before they go on vacation, I guess. Now, Senate Majority Leader Chuck Schumer says they're going to advance legislation to ban bump stocks. But that seems unlikely to get enough Republican votes in this Senate.
There are state-level prohibitions. I think somewhere between 15 and 20 states already prohibit bump stocks. And it may be that more states will adopt those kinds of prohibitions now, given that the federal regulation's been struck down. We have certainly seen in recent years at the state level a lot of action that, we just haven't seen at the federal level. And when it comes to bump stocks, I mean, they're prohibited in not just blue states. I mean, Florida, Louisiana, Indiana, they all have restrictions on bump stocks. So maybe to see some spread there, like with, for example, red flag laws, which, again, more than 20 states have now, including places like Florida. So maybe we'll see action at the state level. It's really rare that Congress passes gun legislation. It happened in 2020 with the Bipartisan Safer Communities Act. But that was mostly focused on funding, community violence interruption, and things like that. There were a couple statutory criminal changes, but it's very hard for Congress to get gun legislation through.
These days, to get any legislation through.
Well, and I think that's precisely why this question of what the agencies can do is so important, because it's true. Like, if Congress were to pass this statute, it would be on stronger footing, but we know that's not realistic, at least it's going to be very hard, and that's precisely why the ATF is, doing things like passing regulations saying, hey, bump stocks, which they didn't know about when they enacted the machine gun prohibition, are functionally machine guns. We're going to treat them the same. Mm-hmm. Like, that's the idea behind that, is the agency is sort of doing what Congress would have wanted in that statute. It's really tough to imagine Congress passing specifically a prohibition on bump stocks, even though, again, 2018, the political winds seem to be in favor.
Schumer may advance the bill as soon as tomorrow, so we'll find out quickly. Thanks so much for your insights, Joseph. That's Professor Joseph Blocher of Duke Law School. Supporters of the bump stock ban include Everytown for Gun Safety, which is backed by Michael Bloomberg, the founder and majority owner of Bloomberg LP, the parent company of Bloomberg Radio. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.